Welcome to Popcorn Planet. I am Andy Signore, and I'm here with Christopher Melcher, attorney at law. And so many people have asked you, Christopher, to help break down this post-trial motion from Amber Heard's team. Elaine has put it out there, and it's filled with some just bizarre, repetitive things that I can't imagine Judge Penny is going to look forward to reading. But let's break this down. First of all, welcome back to the show, Christopher. How are you doing?
Well, doing well, Andy. I hope you had a good 4th and glad to be here.
I did. I heard you did as well. And the fireworks are still happening in the courtroom of Virginia. So it seems to never end. As we sort of go through this, I know you put together a thread to break down some of the stuff. The big sort of weird shocker was this idea at the very end that Juror 15 was an imposter. I want to break that down as well as the other claims. But can you sort of overall, before we even get going into the details, what is this? Is this standard? And am I correct in assuming that Judge Penny is not going to want to deal with this more than she already has?
Sure. So where we're at in the case is obviously the jury has reached a verdict, and then Judge has entered a judgment on that verdict, so saying this is the ruling of the jury and it's official and final. Now, when that judgment was entered, Elaine said that she wanted to file this motion and asked for a hearing date to be set on it. And the judge said, I'm not interested in hearing your motion. Can't stop you from filing one, basically, but I'm not going to set a hearing date on it. And then here she shows up with the motion. She has a right to do that. I think that this is mostly unnecessary because her next step would be to appeal, not to mess around more in the trial court level. But what we see, though, is that to set this up properly for an appeal, you need to have objected to everything at the trial court level. You can't raise arguments for the first time at this higher appellate court level. That just doesn't fly. So what happens sometimes is when people lose a case, that they try and shove in a bunch of late objections. So it's in the court file that's now delivered to this higher court. And so now Elaine can tell the appellate court, hey, I objected. I went to the trial court level. They didn't help me. So now please help me up here. The problem is that with this juror one that we're going to get into, it's way too late. So yes, it's in the court file at the trial court level, but it's way too late. So we're going to talk about that. And then all these other arguments are really rehashing of arguments that were made before. The only new one might be that complaining about the damages being excessive based on the evidence. But sure, she can argue that, but she'll never win that. And we could go through that. But basically, when you look at an appeal, the only ones that have legs, that have any real chance of surviving or doing well, is when it's an issue of law. So if the complaint is like, hey, appellate court, Virginia law doesn't even allow this lawsuit to go forward, doesn't recognize these type of claims, that's something appellate court would look at because it's like a legal issue. But factual issues like there's not enough evidence or they shouldn't have believed Johnny over me, those never succeed. And most of the arguments are, hey, they should have believed Amber and not Johnny. Those go nowhere on appeal. So,
and just to be clear, this isn't the appeal. This is the post motion. And would this then, I obviously this isn't going to like throw the verdict away, but would this then prompt a retrial or would this just prompt a dismissal of the verdict?
So she's asking for kind of all these things in this motion. None of them have any chance of succeeding. But what Amber's asking for in this motion is to say, number one, throw out the entire case, Judge, because this op-ed doesn't mention Johnny, and she's claiming that under Virginia law, to defame a public figure, you have to name the individual in the defamatory piece. It can't be but what we call innuendo. And so the op-ed doesn't mention Johnny. The implication or inference or innuendo is that they're talking about him. And so Elaine's arguing that's not recognized by Virginia law. Now, if that were true, if Virginia law said you cannot sue a public figure unless the statement mentions, the name of the public figure, then that would be a good appeal because they're just like, you can't do it. But Virginia law does not say that, anywhere say that. There's a case, Pendleton versus Newsom, that both sides had cited to that says Virginia recognizes defamation by innuendo. So it can be a statement made about the plaintiff that doesn't mention the plaintiff by name. That's good to go. And Elaine's saying, well, but there's a different standard for public figures. I don't believe that there is, other than this actual malice requirement that to protect free speech about matters of public interest or public figures, this statement has to have been made knowingly false or with reckless disregard for the truth. That's what they mean by actual malice. The jury found that.
Right.
So that's that argument. We debunked that yesterday. That's not going anywhere. Johnny's attorney's all over that argument. That's a big old loser that she's recycling. The other big argument that she's saying is there's no evidence to support $10 million in damages. That's obviously false. There's evidence to support $50 million in damages, and the jury just said, hey, I find 10. That's their role. That's not going to be disturbed on appeal. And then the third thing is this juror 15 was an imposter.
Right. So again, just so a lot of the stuff we've heard before, and he's not entitled to this. He shouldn't have gotten this. Verdict and the complaint counterclaim are inconsistent, therefore should be set aside. The First Amendment bars recovery of defamation by implication of statements are true in the face of a public figure. That's what you just set up. And then yes, respect the statement. Defamation of implication, respect the op-ed. Statement is contrary to the law and is supported by the facts. And there's no support for the conclusion that Ms. Heard initially made or published the headline. The newspaper added the headline, or Ms. Heard played no role. I mean, again, we've argued all of this. All this stuff has been said. Malice, as you said, support does not present sufficient evidence to support finding defamation, which the jury did. And then, yes, down here, the final thing, should conduct an investigation of Juror 15 and whether jury service was proper in due process. And as you said, right away, they had the chance to vet this person. They did vet this person. This is stuff they could have called in more. But I'm still confused. It's all about, as we're going through your thread, which if you haven't followed Christopher over on Twitter, please go do. It's all about the Juror 15's birth year. But Turd points out Juror 15 was clearly born later than 1945. Publicly available information demonstrates that he appears to have been born in 1970. Do you know what public information she's referring to?
Sure. So what happens in jury selection is you get, well, let me back up even a step. If you're in the U.S., you get these jury summons in the mail. And most people try to ignore them. They throw them out. They come up with every excuse that they can so they don't serve on what could be a long jury. And so they get these things in the mail, and it may be a month or two in advance of when the trial might occur. So it's saying, hey, a couple months from now, you need to report for jury duty. And so they send out to a bunch of people. And so they all come down to the courthouse. And every court system is different, but basically what happens is they come down to the courthouse, they may sit in a big jury assembly room or somehow check in, and then if a jury pool is needed, then a trial judge will call in and say, hey, get me 30 jurors. And so they'll bring in 20, 30 jurors, they'll go through selection, try and whittle it down to the amount that they need plus some alternates. And then boom, there's your jury pool. So it's important to know those steps because the implication or argument here by Amber's attorney is that this guy, Juror 15, was lying in wait, hoping to be on the Depp Heard trial, and got a jury summons that was intended for somebody else, and then went and said, oh, I'm going to report to jury duty so I can get on this trial. That's complete nonsense because, number one, nobody reports to jury duty. They try to get out of it. So nobody, wants to do this typically. Number two, even if they really, really wanted to be on a jury, they would have no idea that it's going to be the Depp Heard trial. So it's totally fanciful. But in any event, once you're there as you're the trial attorney, you get your list. So they bring in, and this is why it's Juror 15, because they might have, on a trial like this, might have brought in 50 jurors. Because they're trying to whittle it down to 7 plus some alternates. So they bring in this big pool, they number them. Okay, you're Juror 15. They give you a list as the trial counsel, the name of the person, apparently here their birth year that's stated, their occupation, and I'm going from at least how we do it in LA, how many days your employer will pay for jury service. So some will say unlimited, some will say 5 days. Then in a big case, you'll have jury consultants. Both sides, I'm sure, had jury consultants. So once you get the list, somebody's running out there checking voter registration records, saying like, hey, how does this person vote? They're Googling. They're doing all that stuff. They don't just say like, oh yeah, we'll just take this person and that person.
Right.
This is a very well vetted process. So Elaine, in her ridiculous motion, admits like, I got a list before we selected this jury, and it showed jurors 15's birth year was 1945. And it's clear that this guy, was not born in 1945, was born in 1970. Now, that's a 25-year age difference. Now, I know not everyone ages the same, but, most of us can tell whether 1970 versus 1945. I mean, that's a
big difference.
So, and they admit it's clear. It was a clear problem. And so now they're accusing this juror of being an imposter, which is total nonsense, number one. But number two, it's like you needed to object about it immediately.
Right.
You should have said, hey, judge, we obviously got a problem here. Is either these records are wrong or this juror is not the person that was summoned. And they would have investigated and dealt with it immediately. You don't go through the entire trial after a judgment's entered and then say, I remember that list that I got. Like, what are we talking, like 3 months ago?
Yeah, this is so weird. The facts show that Juror 15 was decades younger than an individual on the jury panel list, raising questions as to whether they are not the same or different people. So that's it. So I guess the person looks younger than what they're listed on this list. Is that typical to get a list of what the birth years are?
Well, I don't. In LA, when I was doing jury trials, we didn't get the birth year, but we got their name, their occupation, whether they've served on a jury before, whether they have any criminal history, and then the days of paid jury service. That's what I get in LA, but I don't know what they do there in that particular court. But, Elaine's saying, I got a list of prospective jurors that had the birth years, and this list showed this guy was born in 1945, and we went ahead and selected him on the jury without objection. And she notes in a footnote, and by the way, if you're ever looking at a legal brief or an accounting report and you want to know where the good stuff is, it's in the footnotes, because
right here.
If you scroll up, the page 41 is where that footnote starts. Right there. So the footnotes are where you put stuff to keep you from lying, basically. So they say all this big
secretly
claims, and then it's a footnote.
It's like my speculation warning.
Yeah. So she makes this really bold claim, juror 15 is an imposter. And then she says, well, the rules in Virginia don't allow us to object based on a discrepancy in jury records. But, and then she finishes the thought on the next page, that doesn't cover this situation where somebody fraudulently passes themselves off as another human, is what she's arguing there.
Man, sneaky. But clearly none of this will affect Judge Penny. I get the vibe, Christopher, that she is just over them, not a fan of them. I've talked to people who were in that courtroom who watched the recent sort of seal of the sentence, the verdict. She wants this done. I feel like she thinks this took too long. Enough is enough. Do you think any of this will affect the appeal process in Amber's favor?
No. So what the judge will do, I don't know if she's required by law to hold a hearing on it. If she is, she'll hold a hearing on it. If she's not, my guess is she'll just deny it. Johnny's team will probably respond to it, and it'll just be denied. There's not going to be a new trial. There's not going to be a dismissal. Nothing of that's going to happen. The purpose, I believe, of this document, as we stated before, is to shove it into the court file, because what we say on appeal is if it isn't in the record below, meaning in the court file, it did not happen. Like, you could have the best argument in the world, but if it's not reflected in this big court file that gets transmitted to the appellate court, didn't happen. So that's what she's trying to do, is shove it in there. I know there's some people listening to this saying, but she can't appeal unless she posts the bond. That's untrue. There's unfortunately been a misstatement here by several folks that have been repeated all over the place. But Amber Heard has an absolute right to appeal, just as Johnny Depp does. There's a very small filing fee, and Virginia uses, I think, this term bond of maybe $500 to cover the other side's costs. So for a very low entry fee, Amber Heard can and will appeal. She does not have to post the entire amount of the $10.35 million judgment and interest to exercise her right to appeal. That's absolutely true. The only reason why she would need to post that big old bond is if she wants to keep Johnny from enforcing the judgment during the appeal. The filing of an appeal is a matter of right, but it does not stop the winning party from going and raiding her bank account. So if she wants to stop Johnny from taking money from her account or property, she would need to post a bond, and that would stay enforcement. But to post a bond, the insurance company or bond company is going to want security, because when and if she loses the appeal, the bond company would have to pay the $10.35 million to Johnny. And they're not going to just say, sure, we love you, Amber, we're going to agree to do that. They're
Right.
going to want security. She does not have $10 million to secure that promise, so there is no way she's getting a bond, but she will appeal. And she could also file bankruptcy. I know there's other people, she can't file. She can absolutely file bankruptcy. Anyone in the U.S. can file bankruptcy as an individual. And it would be up to Johnny to show that it's a non-dischargeable debt. There's an exception in the bankruptcy code. It's 11 U.S.C. 523A6 that says you cannot discharge a debt that was resulted from a malicious injury. And this jury did not determine whether, for purposes of the bankruptcy code, it was a malicious injury. That's a term of art, just as actual malice is a term of art for defamation. So she can absolutely file for bankruptcy protection. Johnny can absolutely come in and say, hey, judge, don't allow this debt to be discharged or changed. The bankruptcy court determines that, not the court in Virginia. So those issues will wind its way through. One other little prologue on that is Johnny will appeal. He has to appeal because the way that the judgment is structured is a judgment against Amber for $10.35 million and a judgment against Johnny for $2 million. They did not offset. And originally I was thinking, well, maybe they would just offset and it would be $8.35 owed. They didn't do that. They're two separate judgments, really. So if Johnny does not appeal, Amber can go and say, Johnny, you owe me $2 million. If you don't pay me, I'm going to take it out of your account. So he will appeal, and he will post a bond for $2 million, not because he has to exercise the right to appeal, but because he wants to stop her from enforcing the judgment. So you will see Johnny, I predict, file an appeal. You will see him file a $2 million plus interest bond that'll keep her from getting his $2 million while she runs through her appellate process. And there's some other things he can do. So don't worry. Johnny's not going to be in any kind of difficulty with the $2 million, but he has to go through some legal maneuvering here while she does her legal maneuvering.
A lot we still have to stay tuned for. A lot we'll keep you updated on, and make sure you follow Christopher Melcher over on Twitter for these updates and legal threads. I like this other one. I knew this trick already, but spoiler alert, this one about the Apple iPhone was very fun. Kevin Smith ruined this ages ago. Any hero or any character in a show, if they're using an iPhone, can't be the villain. Why? Well, you'll find out in that thread, as well as others here on Twitter, over on Christopher Melcher's Twitter feed. I'll put the link in the description, so go click on there, follow him. Always a pleasure to talk to you, Christopher. I'm sure we'll have more to talk about soon. A lot of Britney stuff coming out. I want to try to tackle that with you sometime soon as well. So if you want to catch all of our updates, make sure you hit that subscribe button, hit the bell for all alerts, smash that like button, and leave a comment down below for more. Appreciate you guys. Enjoy your day. We will be live later today around 2 p.m. Hope to see you guys there. Thanks so much for watching, as always, here on Popcorn Planet.